Well, good afternoon, everyone. Thank you very much for joining us. This is the Music Publishers Association's webinar about navigating Brexit. Now, firstly, thank you all our members for joining, all our associates, sister organisations, especially on a topic that generally puts you off your lunch rather than takes it up. So much appreciated. In this session today, which will be first of 3 that will run over the year, we will be looking at how the landscape seems to be panning out in front of us. We know many things are yet to be established, very much in progress, but there are certain things that you need to consider and certain places you can look for advice and support. So today we're looking with our partners here who have various different areas of expertise to help sort of guide you as to where to look really at this stage, to help you do business, to help you work with your creators and your partners and your overseas associates. So rather than me prattling on about what you might do, I'll introduce you to the people here with me today who kindly joined to share their knowledge of the things you might think about over the forthcoming year and years ahead. So I will actually hand it over to them to tell you who they are, what they do, and what their interest in this may be. So starting with you, Naomi.
Hi there, yes, I'm Naomi Pohl and I'm Deputy General Secretary of the Musicians Union. So we've got 32,000 members in the UK, a mixture of orchestral players, featured artists, session musicians, music teachers, but the majority of our members do a mixture of things, and a lot of them perform live and a lot of them rely on touring. So obviously these changes are going to have a massive impact, and we're really heavily focused on lobbying to try and get a better deal with the EU, but also trying to get the advice together for our members on what they might need to do if they want to tour in the EU now that Brexit's happened. And I have to say it's a really mixed bag, and it's quite an unclear picture and constantly changing, but I'll do my best to update you on where we think we are at this moment in time.
Thank you very much, Naomi. So really glad to have you here, particularly representing the music makers position in this picture, and obviously as music publishers, they are very much our partners in life. So thank you for your position. So again, from Jonathan, could you introduce yourself, please?
Hello everyone, so my name's Jonathan Couturier. I am the Assistant Director at the Department for Business, Energy and Industrial Strategy. So I was one of the team that was involved in the EU-UK negotiations on the movement of service providers from to and from the EU and the UK. And I can take any questions on sort of guidance that's available and sort of clarifying what the position is and is not in the negotiated texts.
Oh, careful what you invite there, Jonathan, but thank you very much. Thank you for joining us. And just a quick note on the questions, everyone. If you do put anything you'd like to ask everyone into the Q&A, we will come on to as much as we possibly can if we haven't covered it already. And anything that we don't have time for today, we will still collate and either have on our business guidance page that we have constantly updated on our website, or we'll try to get back to you directly. So do use the Q&A. Thank you. John Phelan.
Hi Lucy, hi everyone. Thanks a million for the invite to speak today, and hopefully we can provide some insights. My name is John Phelan. I'm Director General at ICMP. ICMP is the global trade body for the music publishing industry. We represent the majors, the independents, and 54 different national associations around 5 different continents, 6 if we're speaking in the US. Of course, we're essentially your employees there at the MPA. We're your advocates wherever you send us, and we're there to defend music publishers' interests abroad. And hopefully we can provide some insight as to the repercussions and implications of the cooperation and trade agreement.
Thank you very much, Johnny. And so really useful to have the view from the other side of the table, as it were, of our absolute allies in lobbying around the world. Thank you. Xuyang, welcome.
Thanks, Lucy. Hi, everyone. I'm Xuyang. I'm a senior associate at Taylor Wessing. I'm very happy to be here talking to you all. So thank you to the MPA for putting this together and for having me. The team here at Taylor Wessing has a long history of advising businesses across the music industry, including societies, publishers, labels, licensees and other users of music, and also media industries that have sort of strong relationships and dependencies on the music industry, television being an obvious example. So we get to see a lot of perspectives on the issues of the day, and we advise across the sort of full range of IP, regulatory, commercial, licensing and other contract issues that music clients face. In the last 4+ years, we've given a lot of advice on Brexit in its many iterations during that time. And that's really focused on 2 areas, which I hope we'll have time to cover both today. One is what's changing immediately on exit day, i.e. what's different now, what should businesses be looking out for immediately? And secondly, what are the areas of potential future legal divergence and potential policy change, which don't change anything right now, but that businesses should be, lobbying, responding to consultations, and making the voice of the industry heard. So hopefully we'll have a chance to talk about both of those areas today.
Thank you. Invaluable expertise advice. Thank you very much. And yes, we'll look at what we're all facing right now, the must do nows, the must think about laters, and then we will hopefully have time to come back to you all to look further down the track. And last on the panel, but certainly not least, Roberto, welcome.
Thank you, Lucy, and apologies for being off camera. I'm nursing myself with a bad kind of cold virusy thing at the moment, so I will do my best to navigate through this and have many questions for this exemplary panel, incredible panel we have today. I'm the Executive Vice President of Downtown Music Holdings, and I'm Head of Business Development for Europe, which means a lot of things, including setting up new offices and frequent travel around Europe. So I'm very invested in the outcome of this situation and keeping up to date. Lucy's doing very well on behalf of the MPA, keeping me updated daily with various meetings, etc. But we have many questions that need answering from our exceptional publisher community, who have obviously suffered so much already through COVID over the past year, and having Brexit and trade negotiation outcomes on top of that. It's a very difficult time for them. So I'm hoping we can get to the bottom of some of their questions that they've given me to pose to you all today. So thank you in advance. As you know, our members come in different shapes and sizes and have different needs. So some of these will be a wide range of questions. So if I can start by asking quite a simple one, which is, can I attend MEDEM in the future and conferences around Europe, which is obviously a common thing for many publishers? Can I pose that to you, please? Start with you, actually, Lucy.
Well, MEDEM, I suppose the first answer is, what form will MEDEM take this year? But whilst that's all unknown, I think the question is really, what can we do in terms of the usual course of business for a lot of people in visiting meetings, exhibitions, conferences in Europe? And again, I point everyone to our business guidance page and to that of the governments, that there are exemptions for requiring the extra paperwork, work permits, visas, etc., for short business reasons. And those include fairs and exhibitions, those include business meetings, interviews, I understand. And that is the case so far, is that sort of short-term visiting working, which may be visiting one of your European offices, for example, Roberto, but not relocating to it, as a difference there may be. Now, we're hoping that some of those exemptions expand in various different forms, as I'm sure Naomi will come on to. But in terms of visiting a conference at this time, that would be permissible without the extra regime. I'm sure Johnny will come back if I have got that wrong, and MEDEM is its own world, but do look at the short-term business exemptions.
Do you want to come in, Johnny?
No, just simply to say that we're obviously in discussions with Medium at the moment. We, as ICMP, we hold our annual general meeting there, and they are penciling in the conference for this year. So all steam ahead in terms of the planning. So that's the COVID context, and of course, as Lucy says, the ability to temporarily visit an EU member state, obviously France in this case, is possible for professionals. It, of course, changes in two key contexts I would point out for our industry. One is whenever you're taking up any kind of remunerated work or professional work. And secondly, when it's not just a single professional, someone touring to a conference. The obvious big question is in terms of gigs, hauliers, all of the different professional infrastructure involved there, which is catching a lot of attention. So as a single visitor, indeed, although that's to a single country, bearing in mind the EU, of course, is made up of 27 different member states, so cross-border travel becomes more complicated. Schengen is not the entire coverage area of the EU, so the UK and UK citizens have lost the freedom of movement, indeed the four freedoms which are the pillars of the EU: freedom of movement, capital, services, and trade, and those have been lost with the with Brexit as of January 1, so new rules do apply.
So to break that down, Johnny, I travel around Europe frequently. I might go to Milan, Berlin, Amsterdam, Paris, all in 1 month. Is that possible?
It is, yes. So UK passport holders can spend up to 90 days within the Schengen zone during a total of 180-day period. Yes, that's correct.
Thank you. And Jonathan, did you have anything to add to what's already been said?
No, it's all spot on. Conferences, meetings, trade fairs, exhibitions, all even purchasing or selling goods. All that is authorized as sort of short-term visits. The rules outside of the Schengen area for the limited number of states which are outside the Schengen area but inside the EU are almost identical. It's just that they obviously don't subscribe to the same border code, but for meetings, etc., it's the same. So you could do a crisscross of conferences and meetings across the Schengen area, then pop over to a non-Schengen area state, and that will be fine, so long as it's still doing meetings, conferences, so on and so forth. You're right to point out the paid activity exception. That will vary member state to member state, and that's when you'd have to check the individual rules, because some have quite strict rules and others are more lax.
So just on that, I mean, I know Luxembourg and some other countries have like a 48-hour window that you can go in and work, and as long as you're out within those 48 hours, you're totally okay. I mean, how do we piece together what is and what isn't possible at this time? Can I ask you that one, please, Xuyang?
So as you've mentioned, and as Jonathan's mentioned, what happens when we want to go to work in another member state is completely dependent on the laws of that member state. And short of actually seeking advice across the countries that we're interested in, there's sort of, as far as I'm aware, kind of no central repository of do a survey online and it tells you yes or no. I guess if anyone else is aware of a quick and easy way to get that information, I'd love to know about it.
Yeah, well, I don't know it's quick and easy, but our UK Music, our umbrella body, have cited from its membership that all of this information needs some collation, needs space to look for what the different regimes are. And even if you did have to do something in every member state, some of them may be very easy. So what they are very usefully going to do is coalesce all of that information, and as soon as that's possible, we will be sharing that with everybody.
If I could also briefly jump in there, very sorry, just to specify that. So as you say, there's third party advice out there. There's also the advice of the ISM, which has a page on work permits and visa requirements. The current Gov.uk page is not advice specifically on member state countries, because that poses legal problems for government to advise on another government system, but it does include it's a repository of links to all the member state immigration websites all in one place, and I'm putting that in the chat now. it may not be as useful as a full detailed breakdown, but it's a repository of where to find the information.
Thank you, Jonathan. That's really appreciated. And then going back to UK Music and all of the many meetings we've had over the past week, Naomi's contributed so much and has been so helpful to pull together, obviously on behalf of her constituents being musicians, but musicians are of course songwriters, and if they're not, they're obviously performing songs that we represent as publishers. I just wonder, Naomi, what was agreed in the trade deal? And given all the many daily headlines we're seeing, where are we on this particular subject with regards to touring musicians?
Yes, well, when we first saw the trade agreement, we saw that you can move around freely for up to 90 days in the 180-day period. So we thought visas weren't going to be an issue, but in the last couple of days it's been clarified that in some member states you might need a visa as well as a work permit because you're not a tourist. If you're going to do paid work, you should be declaring that at the border essentially, and you should have the appropriate visa in place. As Lucy said, UK Music are in the middle of compiling this information, and we're trying to do our bit at our end as well to make sure that we've got a list of which territories require visas and which require work permits. And often the work permit will be free, but sometimes the visa might have to be paid for, and we were told yesterday that it might be £80. So we're still trying to piece this information together, and it seems to be kind of rapidly developing. The other things, we've got a helpful flowchart on our website which kind of talks our members through everything that they might need as a touring musician. So it's flagged up on our homepage. I'd encourage everyone to take a look if you need that information, and we're going to be constantly updating it as things change. So you need to have potentially a work permit, potentially a visa. You might need a carnet as well. This is another area where the advice seems to be changing. So we had confirmation from the European Commission that if you're an individual musician carrying a portable musical instrument, so you're traveling by Eurostar, say, just taking your guitar with you, that you shouldn't need a carnet, and you can just go through the green channel. There's nothing to declare at customs. But if you're taking a van load of equipment, then you'll definitely need a carnet. And at the moment we're erring on the side of caution and telling our members that they may well need a carnet, and carnets are £325 and they last a year. We're talking to the London Chamber of Commerce at the moment about whether they could do a deal for our members, and there's some other carnet providers as well that we might be able to get a special rate with. So more news on that to follow. Other areas you might need to think about are if you've got a musical instrument that contains an endangered species, like ivory or rosewood, then you might actually need to have a CITES certificate. It's free to apply. It's an easy kind of 5 or 10 minute process, I think, online. So not terribly onerous, but just something else that you need to think about. And if you're taking merchandise with you, you need an EORI number. And again, you can apply for that easily online. So it's not that each individual process is necessarily hugely onerous, but it's the fact that as an individual musician, if you haven't got a massive team around you, you've got to do that research. You've got to make sure that you do have the paperwork in place so you don't have a problem at the border.
And thank you. Can I just ask what cabotage is? Because this is a word that I've learned over the past couple of weeks, and explain how that's impacting hauliers. Is that something you can touch on?
Yeah, absolutely. Yeah, so cabotage essentially, the rules in the trade agreement are that if you're taking a lorry with equipment, you can only make 2 stops before you have to return to the UK. So this is obviously hugely problematic if you're putting on a big tour and you're planning to go to multiple territories. We understand that you could take the equipment from the from the UK, and once you get into the EU, you could then rent another truck, transfer the equipment into that truck, and then move around freely. But obviously that's quite a faff. And again, something that if you've got a small team, it's just another thing that you're going to have to navigate. It's not ideal. I understand we're trying to get this changed and that we're going for a cultural exemption, because I think those haulage rules are really intended for people who are selling goods. So if you're taking a truckload of meat and you're going to be delivering it, it might be that you do only have a couple of stops. But for touring musicians, it's a completely different ball game. And can I just quickly say on carnets as well, I forgot to mention, we thought that you might need a carnet to go from mainland UK to Northern Ireland. At the moment, that's not the case. But again, I'm told that situation could change. So lots to think about at the moment. Thank
you. I think Lucy, sorry, I think you were coming in. Just
to add some signposting to everyone listening to this very movable feast of a lot of information. The MU are an absolute font of knowledge on this and are doing all the work to try and keep up with the changes, the requirements, what you need to do and where you need to go. So as Naomi says, do check in with them. But what we're doing is, you've seen in the chat, we've put our business guidance page, which links to the MU. We have a flowchart of all the sorts of things you need to think about, what the acronyms mean, where to go. So even if things change, you'll know where to look, and you can come to either of our organisations as we try and translate all of these new pieces of information.
So the next steps on this, Naomi? There's something tabled at Parliament in a couple of weeks. Can you explain a bit about that?
Yes, so an individual technician actually set up a petition really soon after we started to get the details of the trade agreement, calling for a debate in Parliament to try and get some sort of visa-free deal in place to cover musicians and crew. And it's going to be debated, I think, on the 8th of February. I think the debate's taking place at 4:30, and Caroline Dinage, who represents DCMS, she's going to be speaking and talking us through what the issues are. So we understand that the EU had actually offered 90 days of visa-free travel for musicians, but crucially, I don't think it would have been a waiver for work permits. And we understand the UK were a bit resistant because we essentially wanted 30 days. And I can talk later about the routes into the UK for EU musicians as well, which are fairly straightforward, but for paid permitted engagements, if you're just doing a one-off gig, the limit is 30 days. So you could understand why the EU might be reluctant to give us 90 days if we were only giving them 30. So we'd like to get a supplementary deal in place, and UK Music and the MU are working really hard to try and get some traction. And we've had tons of questions in Parliament from MPs. So I think what's really encouraging is that MPs are really aware of this issue, and we've had a lot of press around it. And I think it's made the situation quite uncomfortable at DCMS perhaps. So I'm sure that there's a will to get a deal. It's just how we go about it.
If there wasn't a pandemic right now, Naomi, do you think it'd be even more prevalent, the damage that's been caused based on tours being cancelled, etc.? The headlines would be all over the place.
Absolutely.
I think it's been completely masked by that, so the government haven't really felt the impact of what's actually happened.
Oh yeah, I think if it wasn't for COVID, we'd have musicians struggling at the borders, and obviously that would be a terrible situation. I'm sure there'd be lots of press around the musician equivalent of having your ham sandwich taken away. But in a way, if we have musicians trying to tour at the moment, at least we might get to the bottom of what customs officials actually do, because we can talk about it in theory, but it's not until people start going and trying to do it that we're really going to get to the bottom of how it all works. So it's a bit of a mixed bag. But yeah, I mean, I'm grateful that we don't have thousands of musicians trying to tour at this moment when we're really unclear on what the situation is. But on the other hand, it's difficult to be grateful for the pandemic, which has kind of destroyed the industry, obviously. So don't really want to talk about it as being too much of a silver lining.
Yeah, no, of course not. And Johnny, clearly there's been a lot of blaming going on here. I'm not interested in the blame game. I just want to get this resolved and fix it. You're sat there in Brussels. Tell us what we can be doing on both sides to remedy the situation.
Yeah, well, I mean, first and foremost, I think the first step is exactly what the UK industry is already doing, excuse me, which is mapping the actual implications. We have to remember that the EU is a single market, but it's for the UK now, essentially de facto, it's 27 different countries. So that means you'll have different customs rules, you'll have different visa rules, different work permit rules. You mentioned about some countries which have exemptions, like Luxembourg, for quick visits and a quick performance. But how do you get there? You've got to travel across 4 different countries. What about a large tour, which might be playing in Amsterdam, but is de-rigging in Paris the night before? These are huge questions which simply multiply by the very simple fact and basis that there are 27 member states involved. And essentially, it's now UK musicians are in a situation faced by American, Australian, Japanese touring musicians. It's that same status. What can be done? Well, obviously, a standard mobility clause is what the EU proposed back in March 2020. That was their first opening gambit in terms of the 90-day period that was referred to earlier. The UK subsequently offered 30 days, which, as you can see, is a huge gap. The paid performance engagement was held up, and mode 4 were 2 provisions which were held up as potential fallback options. But again, it was just very far from what the EU currently enjoys in terms of free movement. So without that fundamental freedom of what is the EU single market, of freedom of movement, freedom of services, freedom of trade, that's the whole purpose of being in the EU. It's not in the trade deal currently, and it needs to be agreed via the very complicated infrastructure of the partnership agreements and the governance committees, which have been set up between the UK and the EU. There's 3 main pillars, let's say, to the post-Brexit arrangements. One is the withdrawal agreement, the other is the Northern Ireland Protocol, and then, of course, the trade and cooperation agreement. And as I say, there are governance structures in place between the UK government and the EU and the European Commission and Council to basically review the status of things, to review progress. But we have to ask the political question of, is there political will on the EU side to give something? Because if we think about trade, free trade is a misnomer. When you make a trade agreement, you give something and you take something. There is no such thing as being free and yet having a trade agreement. And when we look at the EU side, they're asking for access to 1 market. The UK is asking access to 27 markets. And therein lies the consistent asymmetry, which is inherent in all of the Brexit discussions. The EU is looking to protect its vast surplus in terms of the goods flowing into the UK, the goods surplus that they have. The UK was looking to protect services. And we left where we are now, a trade agreement which just simply doesn't address mobility. And it's a political question. And the perception within the European Commission currently is trade policy isn't about love or culture, it's about hard numbers and markets and metrics. And that's a hard conundrum to solve, and it's going to take a lot of political goodwill and rebuilding of that goodwill in order to address this. I think it's going to be a tough task, but it's one that's absolutely essential for the music industry, and we'll be doing everything we possibly can to bring that about. It's not going to happen in short order, I'm afraid.
No, agreed. And that's why we need to get to a point of understanding what everyone's needs are and actually home in on the specific issues. And is it worth looking at parallels in other industries as well, do you think? Not just the music industry?
Could I jump in, Roberto? My apologies.
Sorry.
Just before we move on to parallels, which I think would be also quite interesting, just to bring a bit of shed a bit of light on some of the points that were raised about what the trade and cooperation agreement does and doesn't contain. So there's been several references to standard mobility clause at the EU table in its March text. I think we have to be careful here what the clause did and didn't do. It came in 2 parts. The first part is that it was their standard 90-day visa waiver, which the standard Schengen rules for that are business meetings, attending conferences, etc. That didn't include touring musicians. That was the standard binding bit that they were tabling. Now, the UK's position on taking binding visa agreements because of the whole position on the manifesto position on freedom of movement was that that was a difficult one to take. But that was not the bit that contained musicians. The bit that contained musicians was in a so-called joint declaration that was meant to be appended to the visa proposals. The problem with the joint declaration, well, there were several problems with it. The first one is that it was non-binding. It had no legal effect. So even if member states had signed up to it, it wouldn't have obliged them to do anything. That's generally the case with joint declarations. It's an odd instrument in trade agreements. The second problem with that one is that it didn't include work permits, which are actually the major issue, less so than visas. Because anything that's a tour that looks like paid work, then most member states, not all, like work permits to be slapped on. And of course, it didn't include technical staff. And I forgot the main point also, it kept saying ad hoc performances, which, to the best of our understanding, it didn't actually include touring. It included showing up for a gig and going home. It's important to remember that mobility offer had two strands, and one was not as good as it sounds, and the other clashed with the UK's manifesto commitments. The question of 90 days and 30 days, I am curious to know where that information came from, simply because when the UK started floating the idea of permitted paid engagements with the EU, they never allowed us to get into that level of detail. We never talked about days or anything. They told us they told us they weren't interested. But it's true that their declaration said 90 days, but because we were trying to discuss this in the so-called Mode 4 chapter, essentially the chapter about the movement of service providers, and we started raising this to say, we're not interested, musicians require visas, and well, work permits actually, and that's where it sort of broke down. I realize that doesn't helpful in the sense to anyone, but it's just to clarify that the EU's standard offer it's a mixed bag, and the way we tried to approach it was through the movement of service providers, which they shut down immediately. So, I had one more point. There is an interest, it's about institutional architecture. I think you pointed out two things, John, that it's about hard numbers and metrics, and you're very right. The EU's position on UK service providers is that essentially they see us as competitors, so they want us out. But there is a mechanism in the trade and cooperation agreement, a review clause in services, which will allow both parties, if both feel like it, because if one doesn't, then nothing can be done. But can allow both parties to review all of this at one point and see what more can be done. We pushed for the review clause to be included because the EU were saying no to everything. So we said, well, give us at least that. I'm happy to take questions on any of that, of course, but that's what I can share with you right now.
Did you want to come back, Johnny?
Yeah, no, certainly. So just to say that within a standard mobility clause, obviously that's a clause which gets put in place within a trade agreement, but we have to be very careful about the distinction between the single market arrangements. So whenever the UK was a member of the EU, the free movement that we mentioned, the standard mobility clause is the ability for other member states to issue exemptions if they want. So for example, the member state doesn't have to accede to that mobility clause if it doesn't wish to do so. Most don't exercise those exemptions. For example, as I mentioned, Australian artists touring into the EU, very easy to travel cross-border. In Benelux countries, if you're in Brussels, you can easily travel up the road to Amsterdam or to Frankfurt for gigs. So the Council, which is representing the 27 EU member states, it's very important for them to have exemptions to basically say that they agree or not agree to mobility clauses. But it was the broadest and longest way for the music industry and for touring musicians to be able to get into the single market, essentially, and to be able to travel cross-border. Whether member states wish to accede to that or not, of course, is within their whim. The paid engagement scheme, it does indeed make it possible for EU musicians to come in and get out, but again, we have to look at the asymmetry here. If we're talking about London-based musicians looking to get to the EU, it's much more likely that they're going to be traveling cross-border. It's very easy to drive 800 miles once you get into France and travel actually across 3-4 different borders or countries. So there is the need to have the agreement, and there is the need to have the ease of movement and the ease of work permit and the standardization, which is absolutely inherent in the EU deal. And probably politics are put aside, but I'm not sure anyone in the EU wanted the UK out. So that would be a surprising perspective to everyone in the European Commission, Council and Parliament. The political sense in Brussels is very much one of regret and resignation about the UK decision to leave the EU. UK music is so central to the industry, and it's just so loved and adored across Europe. And there's a palpable sense of regret and resignation that it's going to be harder and harder to hear UK musicians in Europe. I think back to the 2 weeks just before lockdown, I had tickets to see the London Philharmonic Orchestra, Bicep and John Hopkins all in the space of 10 days. That's going to be really hard in the future, and that's something we need to solve.
Let's hope our government has the same sense of prioritisation of our music business. But this conversation sort of reminds the likes of me who spend years negotiating copyright licenses with different territories, and we're about to come on to copyright for those questions. So I won't go on about this, but it seems like the government advice at the moment is it depends on who's on the other side of the table. But you mentioned, Jonathan, that there was whereas the EU is saying no to everything, you also mentioned that our government is wedded to its manifesto promises. So I wonder which one trumps. Is it the manifesto pledges or is it the reality?
I can't comment on how on the government's manifesto pledges in the sense I'm an official, not a politician. But
Good answer.
what I can say, I think, is that in essence, the problem was that both parties came to it through different mechanisms, and each didn't agree with the mechanism they were trying to use. I think that's one way to pay, and the reason they came to it different mechanisms because they had their own manifestos in a sense to respect, and the UK's proposal came through its constraints, and the EU proposal came through its constraints. That's wherein it lies. But after that, that's a political matter, which I'm
sure.
not quite well, to comment.
Hope we're now in resolution mode.
If I may just quickly say, I totally concur. The different mechanisms here, what's involved. Jonathan mentioned Mode 4, proposed by the UK in September. That was rejected by the EU, so they did say no to that. They felt it wasn't sufficient to cover touring infrastructure, musicians, and so on. And indeed, that's a WTO agreement, and it would be entirely novel for that to cover musical tours. So that was rejected. It was September. So I think if there was the political will between both parties to agree something between September and the conclusion of negotiations in December, it would have been done. But I think that political will was absent, frankly. We've got to remember that in taking back control, you give back control to 27 other countries and 27 other legal regimes. That's the unfortunate situation we're now in, fragmentation.
And Xuyang, did you have anything to add to this?
No, not on movement of people.
No, okay. Just wanted to make sure you've been there very patiently in the background. And Naomi, did you have anything? Because we need to move on to different subjects, and obviously this is such a hot topic. Anything else you wanted to finish on?
Well, just quickly to say that I think if it looks unlikely that we're going to get a deal EU-wide, I think we are going to be approaching individual member states to see if we can get some sort of consistency as well as clarity on the visa and work permit situation.
Thank you. And Lucy, lastly, how can we keep members updated? I know you're very conscious of that. What's the best to keep this moving picture in the newsletter, or where can people look outside of the Musicians Union's website?
I'd say there's a link in the chat now to our business guidance page to help you just sort of navigate the sort of core topics we're talking about today. We've also produced an infographic which Bella has shared in the chat as well. When I say we've produced it, that's Bella, our comms manager, has, which links to the MU's information, various other sites, the government, talking about Carne's goods, copyright, tax, etc. Various things we can't cover all of today, and things that will change over time. So that, rather than waiting for you to just happen to receive our newsletter, we will signpost to it there, but that will be static on our website and we will update it there. So do refer to that. We'll also do this event nearer another crunch point near the middle of the year where various agreements and developments and reciprocal opt-ins and outs will be in place, and then near the end of the year as it's a sort of do or die point of what's agreed into the future. So both in these forums where you can ask your questions and constantly online is the answer to that. In the meantime, these kind of great activities we have on this meeting today in our team will all available for us to help answer any questions you may have after this event and in between as well.
Absolutely, thank you, Lucy. So we're going to move on. The most prominent and frequent question I've received is, after fighting so hard, and I know personally just how hard Johnny worked on this, the copyright directive clearly was a European initiative, and now we don't currently have that in our primary legislation here. What happens now? If I can ask you, Jonathan, first, please.
Oh, so I'm going to have to disappoint you there. That is way out my portfolio, I'm afraid. I am moving to people. That is a question that I can, however, take to my colleagues at the Department for Culture, Media and Sport, with whom that sits, I believe. I can respond, well, they can respond to that in writing after this.
Xuyang, do you want to?
Sure. So, I mean, as far as I know, and very intrigued to see what Jonathan's colleagues come back with on this. But as far as I know, the UK government has no plans to implement the directive. It is, of course, free to voluntarily do so at any time or put in place something similar. But there's no sort of word on the grapevine that that's going to happen or happen anytime soon. So we'll be in a situation come 7th of June this year where the European member states will have or should have implemented the directive. I actually believe that in a lot of countries there's been a bit of a delay in the domestic legislative process caused by pandemic, among other things. But in theory, on the 7th of June, the directive provisions should be implemented in member states, but we won't have that in the UK. So, I mean, I suppose the areas of most interest, Article 17, rights holders will be able to call on those provisions as implemented in member states in order to hold digital services providers to those obligations for their services as offered in the EU, but not in the UK. The other area of divergence there for this audience would be the fair remuneration provisions in Articles 18 to 22. And it's not terribly clear what the impact is going to be for UK creators and performers there, because the implementation in member states will that will be what governs the extent to which those provisions still have effect in the UK. So, for example, if France implements those provisions into French law in a way that says that all French domiciled creators, whenever they enter into contracts to transfer or exclusively license their IP for exploitation by someone else, regardless of who that someone is or where the exploitation will happen, they must receive these fair remuneration rights. That's likely to have some impact on exploitations and contracts in the UK. Similarly, if France implements that in a way that says, we now in French law have an additional moral right whereby for any exploitation in France, creators, regardless of where they're based, have these additional rights and they can't be waived and they can't, they're inalienable, then UK creators would be able to benefit from those rights in France. So, what actually happens as a practical matter with that will depend on what those member state implementations look like.
And Johnny, as I said at the top of this subject, I mean, you work literally every hour God gave you on this. What advice would you give to the UK right now?
Well, it's a complex issue. I mean, let's start with the most simple point. The UK will not implement the Copyright Directive. That's been made abundantly clear for a long time. Well, we have to look at what the Copyright Directive is. I mean, there are over 35 different articles within the Copyright Directive. It deals with a number of issues, including exceptions, remuneration principles, contracts, platform liability, transparency, neighbouring rights for press publishers. It's a very, very complex and multifaceted piece of legislation. The UK has said that it will not implement it, as we say. So the question becomes, of course, then, well, the two questions are, what happens to UK business operating in Europe, as Xuyang was saying? And the second question becomes then, what is the UK going to do about the Copyright Directive or the policy goals of the Copyright Directive in UK law? And throughout the 3.5 years of the Copyright Directive negotiations, the UK government in Brussels was front and center, instrumental, and the outstanding experts at technical level of the Copyright Directive were in negotiations right up until the point of Brexit on Article 17. And Article 17, of course, offers 3 pillars to the music industry. One is the clarification that user-uploaded content sites, sorry for the jargon, but YouTube, Facebook, Twitter, that these kinds of sites are unentitled to a safe harbor and therefore must take full and fair licenses with rights holders. That's the first aspect, of course, of Article 17. The second aspect is that if they don't take a license or if negotiations break down, they must prevent or stay down unlicensed content that's notified by rights holders. And that's a world first, and it's incredibly important. The UK government was actually quite at the forefront of pushing for that particular provision, given the UK's high value on intellectual property rights, protections against illegal content online, and the outstanding tech sector and content recognition technology services, which many of which are based and long established in the UK. The third pillar, of course, is the transparency obligations between services and rights holders. And I would argue that that's actually the most transformative aspect of Article 17. There is now this obligation among those services to be transparent back to rights holders, including music publishers, both for the licensed context and the unlicensed context. So our hope is very much that the UK will still have these policy goals in mind, given the fact that tackling illegal or unlicensed content online, because unlicensed content is illegal content, is still an aim of the UK government. We hope that that still will be something they wish to do. We're seeing the safe harbor conversation evolving everywhere, from the US even, with the Copyright Office in June this year, in Canada, in Australia. And platform liability is a common denominator of negotiations around the world, frankly, from India to the UK. So we're very much hoping that that will be the push. Why? Because it brings fair value back to everyone in the music industry, from the world's largest platforms, 2 billion monthly users of YouTube, each accessing music tracks. That affects everybody from Ed Sheeran to a single sole trader musician uploading up onto YouTube, and that's why it's critical we address these issues.
Can I add to that as well, John? And we discussed this briefly the other day, that the other piece of legislation that's coming up in the EU, which is the Digital Services Act, also deals with platform liability. It deals with, internet intermediaries, regardless of whether they're a user-generated platform like YouTube, or a different sort of intermediary that hosts or provides a kind of more technical service with enhanced obligations for what are referred to as very large platforms. And the focus there is on requiring platforms and other intermediaries to help to create a safe and lawful environment online. And that includes obligations in relation to illegal content. And the draft Digital Services Act in the EU includes infringing content in the definition of illegal content. So the sort of whole host of obligations in that document that include more transparency and reporting as to what platforms do in response to takedown notices, requirements on some platforms to suspend users who are repeat offenders, there's a concept of trusted flaggers, which can be IP rights holder organizations, notices from these trusted flaggers being given priority, and very large platforms being required to work with trusted flaggers to develop systems and that mitigate the risk of illegal content, including infringing content appearing online. That's all sort of very indicative of movement in the EU towards greater responsibility for online intermediaries of all sorts. In the UK, we also have draft legislation coming out later this year, the Online Harms Bill, which is also intended to deal with illegal content online, but does not include in its scope infringing content. So in terms of the disparity between the UK regime and the EU regime, that's going to be another area, and I suppose potentially another pressure point.
Thanks, Xuyang. And do you think at the very least we'll see takedown and stay down implemented?
I mean, takedown should be happening now anyway. So under the safe harbors in the e-commerce directive, the safe harbors are only available if intermediaries, on becoming aware of infringing content, including after being notified of it, take the content down promptly. Stay downs we don't currently have. So I mean, it would be within a court's power to order a stay down. I'm not aware that that's happened, and that could be another way of dealing with it. You know, if our courts were to hear a case on this and order a platform to comply with the stay down obligation, that would be a movement towards what Article 17 requires.
Thank you. Did anyone else want to come in on this?
I'd just like to reiterate a point that Johnny touched on, that this is a global issue, with the government's emphasis on us now having the freedom to do agreements all across the world. We'd like them to appreciate the maintenance of these standards all across the world. So whilst we have a concern of divergence from Europe here, that's partly because it is the gold standard that we have achieved to be part of in copyright terms. So let alone whether or not this originated as a European piece of legislation or not, we'd like the government to be very aware that this is a global standard that we will continue to be pushing for any agreement they do, EU and beyond.
Absolutely. And Naomi?
Yeah, I was just going to mention the Select Committee inquiry into the economics of music streaming, because that's obviously given us a platform to call for some of the broad principles of the Copyright Directive to be brought into UK law, particularly around fair remuneration. But we've also been talking about the value of the song and also talking about the value gap. So it'll be really interesting to see what comes out in the Select Committee report, because it feels like immediately that's probably our best chance of getting some of those crucial elements into UK law, but we'll see what happens.
Yeah, let's see what happens there. A lot going on in our headlines at the moment. That's certainly one of them. So we'll move on. Maybe for you, Johnny, the exhaustion of rights and national treatment. Has anything been agreed there?
Yeah, so I should caveat my comments here by saying that I'm neither a trade lawyer or a copyright lawyer, so I defer to the expertise. But what I will say is that within the Trade and Cooperation Agreement that the EU and UK have reached, the IPR chapter it's pretty slim. It's pretty good news for our industry in that essentially it doesn't change very much, certainly for the vast majority of companies involved. The first and foremost thing to know about the trade agreement is that it reaffirms the commitment to the international treaties. And of course, copyright is pretty much governed these days largely through TRIPS and through the WIPO treaties and international governance structures, which has been in place for many, many decades. So there was never so much risk to copyright within the Brexit negotiations in that regard. So both the EU and UK have reaffirmed to all of their commitments under those treaties within the trade agreement, and that's a good thing. They've also gone so far as to say that authors and rights holders do have the ability to enforce their rights. And quite notably, it goes on to say that the agreement that's been reached doesn't preclude either the UK or EU from introducing more extensive protection and enforcement of intellectual property rights than is required under the current agreement. So that's a good, hopefully, harbinger of progress along the lines of the topics that we've just been discussing. There are far more ramifications for some smaller issues like orphan works. The orphan works exceptions hasn't been included within the trade agreement. Platform liability enforcement, they weren't included, of course, as we mentioned. But really in the field of IPRs, in terms of the trade agreement, trademark exhaustions, all of those kinds of things will feature much more for trademarks, designs and patents, those other families of IPRs as opposed to copyright. That's really where the ramifications lie.
Can I chip in on exhaustion as well? And I completely agree with everything you just said, John, in terms of reaffirming international treaty obligations and minimum standards of protection rather than maximum standards of protection. On exhaustion, I believe what's happening right now is the UK at the moment still observes a system of EEA-wide regional exhaustion for now. So if there's a sort of physical music product that's sold in Germany with the rights holder's consent and then is imported to the UK to be resold in the UK, that doesn't require an additional clearance now, just as it didn't require an additional clearance before Brexit. However, the same isn't true the other way around. So the EU hasn't, and the EU member states haven't made any commitment to recognise exhaustion happening in the UK. So, products sold for the first time with consent in the UK being resold in an EU member state, exhaustion does not apply, unless member states put in something different. So that's sort of, an additional licensing opportunity in the sort of UK to EEA resale direction. In the trade agreement, the provision on exhaustion is really short. It just says both parties, UK and EU, will have freedom to determine whether and under what conditions exhaustion applies. So the UK is free to take a different stance in the future. And what's quite notable is that in the negotiations, the EU did previously try and commit the UK to continuing with a system of either regional or national exhaustion, and also commit the UK to limiting exhaustion to tangible products rather than digital copies. And the UK has pushed back on that, and that hasn't made it into the trade agreement, which it doesn't necessarily mean that the UK is going to bring in international exhaustion or a different system, but it does mean that the government is free to decide policy on this without any constraints and without any commitments to the EU. And I believe the government is consulting on this matter early this year, so please do contribute and make your voices heard on that.
We certainly will. Thank you for that. Did you anything else to say on this? Anyone else? No?
I have one more thing on copyright, actually, and this is not to do immediately, but just as in terms of areas of potential future divergence. So while the UK has signed up to a copyright term for most authorial works of 70 years plus the life of the author, the UK is expressly free to determine its own rules as to term of protection for jointly authored works, and importantly for musical compositions with lyrics. So whereas now the situation is that the term of copyright is calculated from the based on the last surviving co-author, or as between the musical composition and the lyrics, the last surviving author between them. In the future, the UK does have leeway to depart from that now, and no longer has to follow the EU position on that. So again, I don't think, I haven't heard anything suggesting that the government plans to actually bring in changes in this area. I think it would be politically difficult to row back on the rights that creators currently have. But I think it's just an area to just watch out for developments, and again, include this in lobbying, and if there's a consultation to participate in that.
Can you see any songwriters maybe moving their society affiliations based on being better protected in Europe?
I'm not sure it's a matter for society affiliation. I think it's more a case of if in Europe songwriters who are actually based in a particular country are offered greater protections. So, going back to the new copyright directive and the fair remuneration, transparency, that whole set of protections and rights for creators. If there are particular European countries that that implement those in a way that's extremely protective of creators, then I can see why it would appeal to creators to move to those places.
Okay, thank you. So we've got 7 questions there, so keep those coming. We'll come to you in a second. I've just got one more question to ask, and that really is just extending upon what I just asked, and that really is, can you see any businesses actually having to change the landscape of how they work around Europe at the moment? Is that something you can answer, Jonathan, with regards to tax, or can you see any reason why UK business would need to change how they're currently operating?
So I can't speak on tax. I can speak a limited amount on how service suppliers going to the EU. So here I'm thinking more than just touring. I'm thinking big labels, production companies, and they operate in and if that helps. Broadly speaking, there's if you are a major UK company or you have branches in the EU, you can still send personnel and bring personnel back. It does require, will probably require visas and work permits, but you can move people within a firm. It's called an intercorporate transfer, usually for up to 3 years in the EU, 5 in the UK. So while it would require a visa and work permit, it's quite straightforward. You can provide services under contract in the EU as a UK national. It would probably require a visa or work permit, but the agreement guarantees you the right to do so in a large number of sectors. So obviously the government can't advise whether or how you should change corporate structures, but there are routes to move personnel in and out of the EU, which would mean that you don't necessarily need to revamp everything, if that makes sense. But that might not be exactly what you were looking for.
No, that was precisely where I was coming from and what I've been asked to ask from our members. So Lucy, let's hand over to you to ask what the members are asking via our chat function.
Yeah, thank you. Thanks everyone for contributing to that, and do continue. Some of these points we've talked about either aren't clear, God knows a lot of it isn't clear, but you'd like some more information on specific points or direct conversations afterwards, do get in touch. If you just got any queries for now for this panel, please do put them in the Q&A. Xuyang, I'd just love to come back to you on the copyright side with quite a practical question here from Anonymous. Looking at how the regime changes affect sync licensing, films, TV, advertising. Now, perhaps we could touch on the Kevin satellite issues there. That's licensing on country of origin, but really in a really practical way for lots of our companies. Sync is a fundamental revenue stream and have lots of partnerships and lots of contracts that work across the region. Obviously, there's a question here about how big would your budget be to have to work there, but really perhaps you could tell us a bit about what changes and what doesn't in this environment.
Sure. So we've been advising a lot on licensing and especially clients that have sort of standard agreements and things, what to change going forward. And a key point, and I think one that was raised in the question, is the territory of the grant of rights. clearly now, and even probably from 2016 onwards, simply saying EU isn't necessarily sufficient to include UK as from the 1st of January this year onwards. So do specify UK specifically. I mean, in my experience, licenses generally list out countries specifically anyway. So, for an advertising sync license, it might be Germany and UK and priced accordingly, rather than kind of blanket EU. But in terms of additional potential revenue streams and additional costs for licensees, you mentioned, Lucy, the changes in the SATCAB directive. So whereas previously satellite television broadcasters could have relied on a country of origin system of licensing, i.e. Satellite broadcaster broadcasting from the UK only needs to clear rights in the music in the works in the UK and can then broadcast that work across the EU. Now, additional clearances might be required in the country of receipt of the broadcast, depending on local laws. So that's potentially another a new revenue stream for rights holders and a new cost for licensees.
Do you think, sorry, Xuyang, just in your watching this direction of travel, do you see them accommodating for those budgets, or do you think it will narrow the scope of their broadcasting? Crystal ball question, I know, but obviously our members will be looking at whether these revenues will pick up with that extra licensing or whether the broadcasters will be a lot more selective. Yeah,
that's difficult to say. I mean, I would say that for big budget, major commercial productions, I don't see why a broadcaster would want to limit their market simply to avoid paying music license fees. It's sort of the benefits of continuing to broadcast would outweigh the costs, I think. I'm really not sure. I mean, I think that for smaller budget productions, maybe they would be more selective. So in the sync advertising example that I gave, the reason why advertisers are sometimes quite selective and say that we'll only use a track in, I think I said UK and Germany, is because they're targeting their main markets and it's too expensive to pay for the sync elsewhere. So I think it does just depend on the nature of the production and what the budget is and how much money the producer broadcaster stands to make by distributing more broadly.
Thank you. So perhaps people get used to the sync licenses they do being more territory specific, but perhaps we can also think about placements on a more territory specific basis. Perhaps there'll be options of the music used. Do you think I suppose the other way of putting that question is there something that the publishers can do to meet those considerations that the broadcasters will be having, do you think?
I think that, I mean, I know that broadcasters, a lot of the licensing will be done through the societies, and if it is done directly through publishers, I think it's worth just having the open conversation of, you now do need clearances in other territories, either because we don't have SATCAB country of origin anymore, or because the other example I was going to give is now that we don't have the portability rules anymore. So this is for online service providers, whereas previously online service providers with users in the UK that might offer a particular set of programs, music, whatever it is, to UK users than they do to users in France or Germany. If their UK user goes on holiday or goes on secondment, they can still access their content as if they were in the UK, and that's treated as if it was consumption in the UK. And I suppose going to your question about whether licensees are going to continue to pay more now that they need to pay more for these things, for online services, I think if users have gotten used to being able to do that and now expect that functionality from their service, it's a good commercial point for rights holders in licensing to say, well, now we don't have these portability regulations, and now you do need to clear your rights if you want your UK user to be able to watch, whatever it is that you didn't previously license in France when they go on holiday in France and you need licenses to the music in that. Services are potentially going to be under a bit of pressure because users have just gotten used to being able to do that and would probably be a bit annoyed to find that they can't, and not really think it's a good enough reason that their service provider just didn't want to pay the additional royalty.
So are your viewing numbers more important than your profit numbers, I suppose, is the question. But really, right. Thank you for that. And actually, while I'm with you, there are a couple of questions that we have that relate to tax. Now, as I said right at the top, we're not in a position, and neither is the situation, to give specific advice, but just some general parameters on what's changing and what's not. In terms of, there are a couple of things we need to talk about. One is on the royalty side, one more on the sort of tradable goods. But Xuyang, what are you being asked to advise on tax positions on royalties or copyright revenues?
Yes, we are. So the tax position on royalties, the main concern that clients have is anything changing with the system of withholding tax. And what I mean by that is that in some jurisdictions, some countries, licensees need to deduct the tax that's payable on a royalty that they're paying to their licensor. They need to sort of deduct that at source. And that means that the licensor doesn't get the full amount that they think they're going to get because a bit of tax has come off it before it ever sort of reaches your pocket. And the sort of system of whether there's anything that the licensor can do about that, for example, using it to claim a tax credit here by saying, well, there was this tax payable on this royalty I was going to receive, but actually it was deducted already in Italy, so I need a tax credit to account for that. That's all governed by a system that's outside of the EU, which is whether there are double tax treaties between the country where the licensor is based and the country where the licensee is based. So in almost all cases, none of that is changing. Royalties are going to be taxed in the same way now as they were before Brexit. The only exception to be aware of is intra-group royalty payments. So previously, if you have a rights holding body that's established in the UK and then licenses rights to a subsidiary in Italy, for that subsidiary to then license on for that territory and then have royalties kind of paid back into the parent company in the UK. Previously, while we were in the EU, no withholding tax would apply on those royalties. And now that system of no withholding tax on intra-group royalties has fallen away. So it's possible that tax needs to be paid on royalties that are flowing within a company. If that's a situation that that your membership is facing, and this is really fit for sort of members with a pan-European presence with different entities and royalty flows between them, then that's an area where it's worth seeking a bit of advice and seeing where tax needs to be deducted and how that can be better managed.
Thank you. So again, complicated, and again, the more complicated your business, the more sort of advice you may need, and that's something that we will follow up on and add to our guidance page. So thank you for at least signposting what needs to be looked at. And Jonathan, perhaps you can say a few words on tax implications for the movement of more physical goods. We have a couple of questions. We have lots of questions on this coming to us directly. In the broadest terms, I'm assuming we've lost all kinds of harmonisation aspects. But what would you think are the main considerations for our members? Johnny, do you want to start?
Yeah. Sorry, I mean, again, not a tax specialist, but again, I would just refer really to a couple of key points. One is the whole idea of the single market is this frictionless trade, frictionless ability to for goods and services, and the licensing aspect, I think, is the one with the biggest implications. The clearance of rights from UK businesses into the EU is obviously the biggest issue. On the tax side, again, Xuyang, I think, has laid it out very, very clearly. One further aspect might be Northern Ireland, where the EU's VAT rules will apply for goods, that will continue to apply in Northern Ireland. The UK Revenue Service will keep that revenue, and Northern Ireland businesses can claim it back. That's maybe a little bit of a peripheral issue for the membership, but it shows the complexities in a real test case of how Northern Ireland remaining within the single market and the customs union has implications, and not just for regulation, but on the VAT side and on licensing side also.
Thank you. Anything to add, Jonathan? And it's a tangled web, this one.
Oh, I again, sorry, out of my jurisdiction. Tax is more
Fair
than
enough.
HMRC points.
Fair enough. The point to a department, and we will be pointing to that department as well as this becomes clearer. But thank you very much for giving us some awareness of what we need to think about for now. We are pretty short on time, but lots of questions that we have. Thank you, and we will continue in this vein, and do send to us directly. We will be sharing, as we said again, with everyone, the links to the advice. Our business has got a advice page, our materials that we've mentioned in this webinar as well. Thank you. But one last point, perhaps, before I ask you all to look a bit further down the track, just return Naomi, right at the top. Michael, hi Michael, has asked about the incoming prospect for carnets. Now, we haven't got a great history of being a particularly welcoming country, so I'm sure that affects the negotiations. But again, politics aside, your musicians want to come and go. So what is the picture the UK is presenting to European artists coming in, whilst you're very focused on the other direction, obviously?
Well, I have to say I don't have 100% clarity on this, but we believe that we are a carnet company, so we think we will be expecting to see carnets coming into the UK. Again, I'm hopeful that if you're an individual musician with a portable instrument, you're not coming in a vehicle full of equipment, that you shouldn't need a carnet. But I think if you are bringing a truck of equipment, then you'll definitely need one, unfortunately. The other thing to just very briefly say on musicians coming in to the UK is, obviously we want that to continue. It's really important to the UK music industry, and we've touched briefly on the paid permitted engagement scheme, which enables musicians to come over and do a paid engagement. There's also the permit free festivals route, which has a list of festivals that you can come and perform at without need of a work permit, and we touched on tier 5, which is where you have a sponsor and you can come in for 90 days. So there are routes into the UK. It's not hugely onerous, but it's not what we'd like, which is obviously some sort of reciprocal waiver.
Well, overall, we are, and we as a body within UK music are strengthening our various sort of ways of enforcing the issue on reciprocity, to answer your question, Hugh, and various others that people are waiting on lots of parts of this. That's what we'd like. We are asking them to go back to the table in whichever way they all feel able to do that, and we have other approaches as well up our sleeve to try and push this forwards. But in the meantime, we will be sharing a lot more on the exceptions, the rules, where to look for advice. As we have the last few minutes here, I'd love to just ask you all to look a little further down the track. We're talking about the maybes and the have to do's now, but just a couple of minutes perhaps each on what your sort of red line is, what your core issue is that will take away for our members, and what you'd really like to see this time next year. And Naomi, carry on, I'll start with you.
Well, obviously for us, touring's the big issue, and we are very hopeful that we'll have a lot more clarity, but also that we will be able to get some sort of deal with individual member states that provides a bit more in terms of consistency of approach, which I think will be really helpful to individual musicians. And also, if I'm allowed to have 2 on my wish list, I remain hopeful about the copyright directive, that even though we won't get the directive, that some of the elements of it that are really important for the UK music industry, we've got a lot of friends in Parliament who are pushing for us, and we're hopeful that we'll get some sort of improvement. I mean, we need to remain a really great place for musicians, songwriters, composers to live, and we don't want to see people fleeing the country. So let's hope we can get something sorted in that area as well.
I can agree with you more on that. Thank you. Xuyang, look a little further down the track for us.
So I guess in my key area of interest, which is copyright law, I touched on previously a couple of the areas where there could be divergence in the future. And I would rather that the status quo was maintained and that no moves are made to erode protections under copyright law. For example, I think, the areas of term of copyright and copyright exceptions. The UK has also preserved its freedom to determine for itself. I feel it's unlikely, throughout history, as a general matter, copyright has expanded, in recognition of the value of creative industries. So I feel it's unlikely, but I would like to see that not happen. And I would also like to see that if the UK government is bringing in any reforms, whether on its own initiative or, as part of what might be talked about in trade deals, that's done in a way that is well informed and considered, and considers input from the music industry and the people that will be affected by the various measures, and in a way that acknowledges that the industry is made up of a fine balance of a lot of different rights and interests, and tinkering with bits of it can actually have unintended consequences. So I would like any reform to be done in a very well considered way, with heavy industry input.
Wholeheartedly agree.
Thank you, Xuyang. Johnny, I was going to ask you about further down the track, but also just to see if you can quickly answer a couple of the questions. What Article 16 is that Andrew Martin referenced, and also what's happening with physical product as far as your knowledge, any changes there. German record plants obviously being very dominant over the years, and we're hearing of someone buying a €10 CD in the UK at the moment, but receiving a £20 VAT charge on top of that, which is obviously not workable at all. Just if you can briefly talk about the future, but equally just quickly answer those questions, if you don't mind.
Sure, Roberto. Yeah, just on those couple of points, Article 16 of the Copyright Directive, it's quite a niche one actually. It was specifically put in there to deal with a legal case called the Reprobel case, which basically threw into doubt the status of music publishers as rights holders whenever an author or composer transfers their rights to a publisher. It was quite an unusual ruling. It had caused some problems in recent years, and Article 16 was designed to address that. So basically it clarifies that that publishers are indeed viable rights holders whenever authors transfer their rights to them. So it's quite a niche one. On the movement, say for example, generation and manufacturing of records and transfer, of course, we're seeing some headwinds, some inefficiencies in terms of deliveries at the moment. Again, I'm not a VAT specialist, but my understanding is that there will be no VAT applied below £135 threshold. But again, I would encourage everyone to refer specifically to the UK.gov site and to the UK MPA site for that, because there are some fees which will apply on goods coming into the UK over a certain threshold. So just on those. I mean, on the broader question, I mean, it's a whole topic in itself, Brexit and where to go. I mean, the topic today, navigating Brexit. I mean, the whole problem with navigation is you're supposed to know where you're going. And the rationale of Brexit is divergence. It's the whole point is to step away from the European rulebook. And the question is, we don't really know quite where we're going at the moment. What I would say in mitigation is that, you know, if you look back over the last 17, 18 years of EU legislation, in and around 55 to 65% of UK legislation is stemming or derived from EU law, if you include statutory instruments. So that's providing a sense of continuity, a sense of status quo for the moment. It's not having a huge impact on the contractual and commercial side for music publishers, but it's going to increase over time, and that divergence is the key thing. The UK now exists in a separate market to the EU. And the question is not about day 1 or day 10 of Brexit. The question is about day 1,000 and day 10,000 and what will happen. Will standards of copyright be changed? Will standards in goods and services, platform liability? All of these are key questions for the way ahead. I think there's lots of different lenses we can look through this fascinating topic. There's the regulatory side, we've talked about the legal side, the commercial side. There's the political side, the need for the fertilizer of agreement and is goodwill and cooperation. And we need to see the UK's voice strongly being heard and the industry voice strongly being heard in the EU, because the EU doesn't go away with January 1, 2021. It is the biggest trading partner for the UK, and we need good rules which are closely aligned for UK business to thrive in the EU and vice versa. So I think alignment and making sure that there's good information flowing from ICMP back to our members and in the UK and vice versa. We've constantly said to yourself, Roberto, and Paul and Lucy, that if anything, this redoubles our efforts to make sure the UK industry is more than ever heard within the European Commission, Council and Parliament, and that's not going to change. There's a cultural aspect to this too. We really hope that UK music will continue to drive up in value, and that integration and cooperation will continue to happen. We look at the Erasmus scheme, which has been lost with Brexit, the interchange of students at university placements. That's a cultural repercussion, which I think is tremendously unfortunate. So looking further down the line, I think we want to heal whatever wounds there are there in the political goodwill side as quickly as possible to really get into the nitty-gritty of the infrastructure, of the new governance structures. How does the UK best be heard within Europe and vice versa? And ensuring alignment and prosperity, because the end use problems are our problems. The music industry has to be aligned to drive up value and benefits for everyone across the music industry. Music publishers' problems are performers' problems, are songwriters' problems. And all I can say is that ICMP, whatever we can do to help, step one here is mapping the practical side, the touring side. We'll help to map that. We'll help to bring the diplomatic efforts we can to address the issue. But we need to keep doing this on all copyright and commercial issues for the next 2, 5, 10 years and see where we land.
Thank you very much, Johnny. Jonathan, I'd love you to look down the track, but also in answer to a question asked here and much asked is, we're asking a lot of these questions in all of these contexts are about reciprocity and smoothing the way for business, particularly at a time when we really, really need to do business to recover and to be the incredibly productive sector that we have been in years past. What is the will, and what do you think is the likelihood of the government establishing much more of a harmonised and reciprocal relationship with the EU?
Thanks. So always a danger there of official speaking for politicians. Oh,
it's all right. You can deny everything afterwards. No one's watching.
Well, so I'd say that 3 things are happening which are indicative of the will. The first one is that the Secretary of State for Digital Culture, Media and Sport has agreed to set up a sort of working group with the sector, which I believe he announced in a ministerial call with probably some of you were probably on that call, which will be looking into all of these issues, whether that's mobility, tax, copyright, so on and so forth. And I'm actually about to jump on the call precisely about that working group. So that group will kind of be there as to it's the structure to be heard and to make the case directly to politicians. The second thing is that the government is exploring other ways to help the industry. Now, I'm not saying that as a vague dismissal. That work is actually underway, but the only reason we say exploring is because we're not ready yet to refine and make public some of the ideas. The third thing is that, so I know bilaterals get mentioned a lot. And so bilaterals, just from a purely technical official perspective, there's a problem with them is that the European Commission absolutely hates them. And that anything that they can do to get in the way of that, they are likely to do when it involves the movement of people or things related to trade. That's not to say it's impossible and that there are, of course, precedents and ways around it, but I'm just cautioning around how the European Commission views bilaterals. That's not to say that things are impossible. I think the working group that DCMS will be chairing will be the venue where all future announcements on what is possible will happen. And that will rapidly gain traction in the next few weeks as the team heading it up get to work. That's all I can say from sort of official perspective. Otherwise, watch the space, Parliament, the media for the rest.
Positive direction, at least. Thank you.
So we're just 2 minutes over time. Thank you so much, Johnny, Jonathan, Xuyang, and Naomi, for your insights. It's clearly a moving picture, and I know on behalf of our members, we really appreciate everything you're doing, which helps us. So, and of course to Lucy, Natalie, and Arabella, who have put this on today, thank you. And yeah, let's continue the conversation. Happy to answer any questions myself. Lucy's certainly happy to doing everything we possibly can. But as I say, it's a moving picture. There's a lot more we can all do on this. And just thank you all for today. And hopefully it's been useful to everyone listening. Thank you.